Thank you very much. Thank you very much for coming. I'll begin by asking some of my own questions before passing it over to the audience. So my first question is to do with politics of the Supreme Court. Do you believe that the Supreme Court is a court, or is it more of a third legislative branch in the United States?
Yeah, so I know that it seems to many, particularly to many here, I suspect, that the Supreme Court of the United States is an inherently political institution and even a partisan institution. And I think that's because of the fact that so many of the most important issues facing the United States, issues of governance but also social policy issues, end up as cases in front of the court. And that's unusual. It is unusual, and it does create this risk, I think, of the perception that it's really a partisan political institution more than a judicial one. That having been said, my sense is that as a subjective matter, the individual justices believe that what they are doing is law and not politics, that they have well-developed judicial philosophies, that each of them, in his or her own way, believes that he or she is constrained by legal materials, in that there's only a certain range of outcomes that are legitimate, consistent with the existing legal materials, be those materials the text of the Constitution, the precedent that is on the issues that are before the court, and the general norms and understandings about the proper role of the Supreme Court in our system. And I do think that those feelings, sentiments, views are genuine, and I do think that they in fact act as a constraint on the justices. And probably the most prominent example of that in my own time was actually the decision of the court and the decision of the Chief Justice in particular to vote to uphold the Affordable Care Act. That was a constitutional law question, and the issue there was whether the enactment of that law was within the power of the federal government, as our federal government is one under the Constitution that is of enumerated powers and doesn't have a general police power. And the question was whether this law was within one of the enumerated powers. And there's no chance in the world that Chief Justice Roberts liked the Affordable Care Act, or thought it was good policy, thought it was something he wanted to see enacted. And he had the choice. It came down to him, because otherwise there were 4 justices going one way on the constitutionality of the law, 4 going another way. And it came down to him to decide. And he decided to uphold the law. And so I think that tells you something, that he felt that the legal materials constrained him to rule in a certain way, which I am certain is not in accord with his partisan political preferences.
Is that an exception, though?
I don't think so. I think when you think about whether it's a partisan institution, I think what you're seeing, and when people decry outcomes as partisan, I think what you're seeing is that there's a certain amount of flexibility or indeterminacy in the legal materials, so that you can justify more than one outcome as consistent with precedent, as consistent with constitutional or statutory text, as consistent with the overall governing norms. And so it's easy enough to slap the partisan label on it, but I do think in the main that something else is going on.
So if you believe that the judiciary system is entirely politically neutral and independent...
I didn't say that.
Right. Why are the appointments, why are they so political?
Right. I didn't say that. I don't think it's entirely neutral. I think that at some level, in some respects, people's ideological and political predispositions seep into their analysis. I think that's inevitable. It's human nature. I think it happens. And I think that when you see just how politically intense the nomination process becomes, particularly for the Supreme Court, you have to realize that it's not a neutral process. There's not a strict separation of law and politics and governance through politics. There's not. But also what you're seeing there is a battle over judicial philosophy. I mean, I really think that at the end of the day is what you're seeing. You're seeing one political party tends to have a view of the role of the courts that is different from the view of the other political party. And there are powerful arguments to be made for each view, and those views are contesting, and that contest plays itself out with Supreme Court nominations. I think it would be better overall for the system if you could ratchet that back, because I do think it's gotten more intense and has become more of a dominant theme over time. But I see that as much more a battle about judicial philosophies than about just like so purely partisan. They're going to vote the Republican line or they're going to vote the Democratic line.
And with regards to these appointments, do you believe that the lifetime appointment system that is used to choose Supreme Court's judges is the best model?
No, I don't. And my experience in the last 5 years as Solicitor General has kind of brought me to that conclusion, that I think we would be much better off. I think lengthy, I don't think we should. I think appointment as opposed to election of judges is quite important and I would never want to see that changed. I think the principle that a judge's salary and position can't be negatively affected by legislation for the judge's tenure is a good thing, shouldn't be changed. Those are integral to the independence of the judiciary. Life tenure is not integral to the independence of the judiciary. So long as you had a sufficiently long term, and I think one number that people talk about is 15-year terms, I think that would be a healthy thing, because there would be more turnover, and the more turnover there was, the more turnover, the less political each decision would be, and the more random the decisions, they would come up at random times, and in that you wouldn't have the situation you have now where you have justices hanging on until their own political party is going to do the nomination of the replacement. So I think it would change the dynamic. I think it would change the dynamic in another way too, in that now there's a lot of pressure to appoint people who are young to the Supreme Court in particular. The ideal candidate is somebody who's maybe 44 years old, because you're hoping you can get 40 years out of that person. And if you eliminate life tenure and you've got 15-year terms, then that incentive goes away too. And I think that would be a healthy thing.
And you've just mentioned the fact that the appointments are now younger and younger, yet life expectancy is progressing further and further. Right. Is that a problem that individuals are staying on for 30, 40, maybe 50 years going forward?
Well, it depends on what you mean by problem. I think that the more senior justices are fully capable, they're fully engaged, they have plenty of energy, they're doing an excellent job. So it's not detrimental to the system in that sense. I think that the issue of the length of tenure is more that, when someone is nominated when they're in their early 40s, and then if they serve until they're 80, the world that when they're 80 is a vastly different place than the world when they were in their early 40s. And yet they may be still where they were 40 years ago, and I think that's kind of where the problem is.
Well, let's move on to the topic of marriage. And you mentioned Supreme Court Chief Justice Roberts, and he stressed his view that the court's 5-4 ruling legalizing gay marriage nationwide lacked a constitutional basis. Would you have preferred for introduction of gay marriage to go through the government, as it did in this country?
Yeah, so let me just talk about that at some length, because that's a really important question. And I'm actually going to not start with the Supreme Court, but with President Obama and the decision to shape what position we should take, how we should shape our position. In our system, the Solicitor-General generally exercises a great deal of independent judgment in deciding what the United States government is going to say to the Supreme Court, and does so in a manner that is designed to be, and by norm and tradition is, free of partisan political considerations. And I was given a great deal of latitude during my time as Solicitor General to make those kinds of judgments without any interference from the White House and without being overruled by them ever. And I generally just went about my business and made the decisions. There was one time, though, that I thought that the president ought to make the decision, not me. And that was on the question of whether the United States government should take the position in support of constitutional marriage equality. It was quite a consequential decision, had enormous implications in all kinds of ways. And so I asked for time to speak to the president about it. And it was the only time in my tenure that I did that. In any case, asked to go see the president, and I did. And I went in, the Attorney General and I went in, and we had a meeting with the president. And it was really one of the more remarkable experiences of my life, this meeting with the president, because when I went in and I was trying to explain to him what the issues were. And this was not in 2015, 2016, at the time of the Obergefell case that actually recognized the right of marriage equality. It was a couple of years earlier when the issue first got to our Supreme Court in 2013. And the question of marriage equality came before the Supreme Court in 2013 in the context of a case involving a particular proposition that the voters of the state of California had enacted banning same-sex marriage, and whether that was unconstitutional. And it came before the court at the same time that the court was considering the constitutionality of a federal law called the Defense of Marriage Act, which denied any recognition for federal benefits purposes to any same-sex marriages that any states might recognize. And the United States government was actually attacking the constitutionality of the DOMA statute because we thought it was a violation of the equal protection of the laws. And we had to make a judgment about whether we would come into the other case and take a stand on the marriage equality issue. And there were very strong pragmatic reasons why it might not be a good idea to do that, namely that it was imperative, we thought, to win the DOMA case. And if we took a position in the marriage case that was up there at the same time as the DOMA case that indicated that if the court ruled for us and struck down DOMA that it necessarily implied a right to marriage, that might act as an inhibitory factor and lead them not to recognize the marriage, not say that they're not ready to recognize marriage yet, and therefore they're not going to rule for us on DOMA. So that was a really serious consideration. So I went in and kind of explained this to the president and said, this is the argument against it. Now here's the argument for it, I thought. I laid it out, and I said, and I thought, in my judgment, the argument for it ought to take precedence over the argument against filing. And his immediate reaction was, and I'm linking it up to your question now, his immediate reaction was, well, but this kind of change really ought to come through the political process. And then he talked about his daughters, and he said, for Sasha and Malia, everybody their age thinks this is a non-issue, so this problem is going to take care of itself over time. And so why don't we just leave this to the political process? The change will be more enduring. It'll be less likely to generate a backlash. All very powerful points. And then, the moral of this story is not that I convinced the president to do this, because I'm quite sure that he was going to do it anyway, but we were having a really interesting discussion about it. But what I said in response to that, which is really a response to your question and to Chief Justice Roberts' dissent, is that I thought what would happen in the United States would be pretty much a repeat of what happened with race, and that you would have a majority of the states in the country recognize marriage equality, but you would have a sizable minority of states in the country that would not recognize marriage equality. And then I thought, and so think about what that says if you are gay and lesbian living in one of those states, or in particular, if you have a child who is gay or lesbian and growing up in one of those states, or growing up in a state that is the laws of which are telling you that there is something wrong with you, that you are a second-class citizen, at best a second-class citizen. And that was something that I thought we shouldn't tolerate. And that the last thing our country needed was to replay the sad story of race with respect to sexual orientation. And then he said, this was the really remarkable part of this meeting, then he raised, at that point, Martin Luther King's letter from a Birmingham jail. I don't know how many of you are familiar with this, but it's an iconic document in American history, really. And he's talking about the letter. He says, this is just like what Martin Luther King said. And I, by chance, had happened to read the letter from a Birmingham jail the evening before in preparation for this meeting with the president. And I had a copy with me. And I pulled it out of my folder, And I said to him, yes, Mr. President, it's just like this paragraph right here. And I read the paragraph where Martin Luther King is talking about his young daughter and having to tell her that she can't go to the amusement park outside of Atlanta, Georgia, because of the color of her skin, and watching the clouds of inferiority form in her young mind. And at that point, we were in agreement we were going to file that brief. He didn't give his formal okay at that point, but at that point we were in agreement that we were going to file that brief. And so, long answer to the question is yes. Would it have been better that the political process solved this question in the United States? Definitely would have been better. But it was not realistic to think that that was going to happen in a comprehensive way. And we do, after all, have a Constitution that guarantees every person the equal protection of the laws. And, our Declaration of Independence said that we were a nation committed to the principle that every person is equal. And when it becomes so patently clear that laws that the refusal to recognize marriage equality is a denial of that basic equal protection, then the law does command this answer. So, very long answer to the question, but obviously something I've thought about a lot, and that we thought about a lot, and that the President thought about a lot before we decided to take the position.
And with your active role in these nationwide changes, did you feel that you were making history and you were, creating this progress yourself?
I wouldn't put it that way. The way I would put it is that I felt like I was part of history. It was anybody who gets in our system to have the job of Solicitor-General is incredibly, incredibly fortunate. It is the ultimate lawyer's job in the United States. It is an incredible thing. And everybody who's had it has said it's the best job they've ever had, including people who've gone on to become Supreme Court justices who had it. And so it's true for everybody. It was especially true for me because my 5-year tenure was quite an unusual time in our history. It wasn't the only time in our history this was true, but it was one of the rare times it was true where there were so many issues of great importance that came before the Supreme Court in such quick succession, term after term after term. Most Solicitors General might have 1 or 2 landmark cases in their tenure. I was having 2 or 3 a year. And it didn't have anything to do with me. I just happened to be the person who was there at the time. So I didn't feel so much like I was making history, but I definitely felt like I was part of history in a way that not everybody is fortunate enough to be.
And President Obama mentioned too that there shall be backlash that we saw in November. Do you feel that you're partly responsible for Donald Trump's success?
People have said that. I think that's crazy, actually. I think that's crazy. Of all the things, of all the reasons, I don't think so. I don't think we really had very much to do with it. If anything, we'll see what happens, right? But I'd be very surprised if the Supreme Court reverses course on marriage equality. And so, there's been some modest backlash to that, but not very much, especially when you contrast it with kind of extraordinarily violent and enduring backlash we had to legal decisions requiring racial integration. There's been nothing remotely like that. And then with respect to health care, the Affordable Care Act, there was a lot of clamor for years about how horrible it was and how it needed to be uprooted and thrown out. And now the question of whether to do so is actually a real question. You watch what's happening in our country. There's actually a great deal more support for the law, and it's becoming increasingly difficult for them to uproot it. We'll see. Maybe they'll succeed at it, but it's looking like that's going to be very, very difficult for them. So I actually know when I think about that, I don't really think Donald Trump's election had very much to do with what we did, because I think those things that we did, I think, are going to endure.
Are you scared that Trump will be able to appoint judges who will tear the Affordable Care Act down?
So, at this point, the law's been upheld as constitutional, and then there was a second very fundamental statutory challenge to the law, and the law was upheld in the face of that. I don't think the threat to the law really comes from the judiciary at this point. I think to the extent it's at risk, it would be at risk in the legislative process. And as I said, I think that's actually going to be hard for them to accomplish.
And the last question on Trump, if you don't mind, is to do with Sally Yates. And obviously, she refused to have the Department of Justice defend his temporary ban, etc., and was fired. Do you think that it was your role to defend the president consistently, or it was your role to act independently and make your own judgments of what is best for the country?
Yeah. I'm going to give another long answer here to this one, but I think to understand the role of the Department of Justice in our system, and the role in particular of the Solicitor-General, but also the Attorney General in our system, you have to hold in mind at once two ideas that are in tension with each other. So on the one hand, the Department of Justice, like every other department or agency in the executive branch of the government, is a policy-making organization. It carries out the policies that the president has decided he wants to implement. And a good example of that would be reduce the levels of incarceration in the United States, or reduce the level, relatedly, reduce the levels of sentences for drug offenses, that sort of thing. But the Department of Justice has a second and vitally important responsibility that other cabinet agencies and departments don't have. And that is to ensure the integrity of the rule of law, because the Department of Justice is the part of the government that is bringing criminal prosecutions and bringing civil actions and making the judgments of what positions the United States will take in court. And so they've got a responsibility to do that in a way that isn't partisan and isn't perceived as partisan, because the system would unravel if all of that were just perceived as just another exercise in partisan politics. And that means you've got to make independent judgments about where you draw the line. And there may well be instances in which, as a policy matter, the government wants to do something, and the president and the White House want to do something, or a cabinet agency wants to do something with the White House's support, but you can't do it, and because it's just not consistent with the rule of law. And I'll give you one example. It's a little bit arcane, but it sort of helps illustrate it. During my last year, a case came before the Supreme Court that involved a question about the status of Puerto Rico, which is a commonwealth that's part of the United States, but it's not a state. And the essential question came up in a criminal law context, but the essential question is, how should we think about Puerto Rico under our Constitution? Should we think about it as a sovereign that has the same level or a parallel level of sovereignty to a state? Or should we think about it as a territory that doesn't have that kind of sovereignty and is subject to the plenary control of the Congress? Now, for many years, Puerto Rico was considered as a territory that was subject to the plenary control of Congress. In the 1950s, the Congress enacted a law that gave Puerto Rico a great deal of autonomy. It said you can become a commonwealth, you can have your own constitution, you can govern yourself with your own laws within very wide limits. And so Puerto Rico was arguing in this particular case that meant it wasn't a territory anymore, and that it had a status equivalent in many respects to states in terms of sovereignty. And the White House really wanted us to agree with Puerto Rico on that for various reasons. And I looked at it and I felt like we just couldn't do it, because the power that was bestowed on Puerto Rico to enact its own constitution was given by the Congress. And one of the fundamental rule of law values in our system is that a subsequent Congress can always change what a prior Congress had done, that a prior Congress can't bind a subsequent Congress, and that you just couldn't do what Puerto Rico wanted to do and what the White House wanted to do on Puerto Rico's behalf consistent with that rule of law value. And so I said, no, can't do it. Can't take that position. And they respected it. And that was true in every instance in which, and there weren't many, it's not like this is happening every week. This might happen a couple of times a year at most. But when it happened, invariably the White House would back off. And so, and I don't want to prejudge things with the new administration, because they haven't been in office very long. They don't even have a Solicitor General in place yet, so it's a little bit early to make judgments or cast aspersions. But given who the president is and the predilections that the president has thus far shown as president and beforehand, you're really going to need a Solicitor General and high-level officials in the Justice Department who have a great reservoir of not only of integrity but of courage because they're going to have to say no, even in the best of circumstances. I mean, I basically was on the same wavelength as President Obama almost all the time. But even in the best of circumstances, you had areas where you just had to disagree. And I feel pretty confident those issues are going to come up in this administration, and perhaps with a greater degree of frequency, probably with a greater degree of frequency, and probably in issues that, at a very high level of importance. And so in order to maintain those rule of law values, at the end of the day, that comes down to norms and it comes down to personal courage, I think, and personal integrity. And so it's going to be very important who's filling those roles and their willingness to act with integrity and courage.
And my last question too is to do with your career, and obviously you've had a long career both privately and publicly, but no doubt your last role as a Solicitor-General taught you a lot of lessons. What do you think the biggest lessons that you've picked up from your time, and what one piece of advice would you give to the next Solicitor-General who will work under President Trump?
So I'm going to spin that question a little bit of a different direction, but then I'll come back and answer it directly. So I promise I will. And if I don't, you'll remind me, and then I'll do it.
I will do.
So one of the things I learned by becoming Solicitor General was this. And given, when I stare out at all these extraordinary young people here, I think it's important to say this. Had I became Solicitor General, I think, because of choices that I made when I was young, a young lawyer. But they were choices that you would never have made if, as a young lawyer, you were planning to end up as Solicitor General. And so I think there's a real lesson there. And here's what I mean. I came out of law school, and I had a couple of judicial clerkships, and I started practicing law in the mid-1980s. And one of the first things I did when I went into the private practice of law was, as on a pro bono basis, I took on representation of inmates on death row, challenging their death sentences, the lawfulness, constitutionality of their death sentences. Now, in the United States in the mid-1980s, views about capital punishment were quite different than they are now. Now the country's sort of about evenly divided as a theoretical matter, and the number of death sentences being imposed and the number of executions being carried out is very, very low. But in the 1980s, it was quite different. It was 80% approval in the polls for capital punishment. Lawyers who took on these cases were viewed as basically saboteurs, people just trying to throw sand in the gears, and a lot of law firms wouldn't even take them on. And had I, as a young lawyer, said, gee, I'd like to be Solicitor General someday, but I know I'm going to have to be confirmed by the United States Senate for that job, so I better avoid doing anything controversial that might come up in my Senate hearing and prevent me from being Solicitor General. I would never have taken on those cases. But I can sit here tonight and say to a moral certainty that had I not taken on those cases, I never would have become Solicitor General. And that's true for two reasons. One is that before I went into the government, I had argued 12 cases before the Supreme Court as a private lawyer, and that was the thing that kind of gave me some credibility as being considered as a person who could have the job of Solicitor General. And 5 of the 12 cases were on behalf of death row inmates. And so a huge amount of the experience I had came out of taking on that work. And then beyond that, I learned how to be a lawyer through that work more than anything else, because it was incredibly challenging, demanding work. I would have to go down to these communities, often in the South, Columbus, Georgia, Gulfport, Mississippi, and do factual investigation, trying to get facts from people who are incredibly hostile to me and to me being there. And then I would have to argue these cases in these county courthouses in these states, and then work them up through the system until they eventually got into federal court. Had to make judgments about which issues to push, which issues to leave on the side of the road. All of that happening in a situation where if I screwed it up, my client was going to die. I really learned how to be a lawyer doing that, and in ways that I just wouldn't have through any other work that I had done. And so, as I said, I'm quite certain that I would have, that it is that work that led to me ending up as Solicitor General. So, obviously this is advice, that Don't try to map it all out in some savvy, strategic way, because the odds are really high it's not going to work out. Do what matters to you. Do what you think is important. That is much more likely to get you where you want to go in the long run, much more likely. So that's my advice for you, not my advice for the next Solicitor General. But my advice for the next Solicitor General is going to be a bit of a replay of what I said before, that of all the things that matter, acting with integrity is what matters most in that job. You can be a brilliant writer, you can be a brilliant oral advocate, you can be a master of legal pyrotechnics, and all that's good. It's good, it helps you. But what matters most, and what is the way in which you're going to ensure that you're a success as Solicitor General, is to act with integrity, such that integrity that the justices can observe and recognize and respect, integrity that your peers in the government will respect, so that when you've got to give them hard news that they don't want to hear, telling them something that they can't do something they want, that they're going to respect it because they know it's coming from the right place. And then integrity with the people you lead, the vast majority of whom are career civil servants and not political partisans, who need to know that the decisions you're making are being made for the right reasons. And so that would be my principal piece of advice.
Great. Thanks, Mr.
Sure.
Verrilli. I'll now let students ask their questions. So if you'd like to ask a question, please raise your hand. If we can go to the 6th row on the aisle. Thank you.
Hello, thank you so much for coming. You kind of speak on human rights and the human rights that kind of Americans want to uphold. And so I just kind of wanted to, on a more social justice and human rights sector based topic with regards to cases and hearings that might not make it to the Supreme Court. But could you just speak on the number of sexual assault cases and kind of potentially racist cases that have happened in the United States? Specifically, I'm thinking of the Brock Turner case that hits home geographically, or the recent Idaho case that I was hearing of today, with the potential assault of an African-American mentally challenged 19-year-old. But just specifically, these two cases are kind of hitting home in American universities. And so what your perspective is of mainly kind of Caucasian judges ruling in a way that to civilians seems to be a breach of equality. So just kind of your thoughts on that and how that relates to our justice system.
Yeah, I don't know enough about the particular cases you've identified to talk about those particular cases, but I'm happy to talk about the subject in general. I mean, yeah, yes, very significant amount. We're now seeing, because people are having the courage to come forward with respect to sexual assault, that it's a problem that is pervasive and it occurs a lot, and it's a very serious problem. And so people having the courage to come forward is a really good and important thing. With respect to issues of assault around race, they have always been a horrible part of American history. Unfortunately, and I don't know that I would be ready to say conclusively that it's causative as opposed to just correlation, but they've been on the rise in the last few months, and that seems like a serious problem too. And that's a problem that you've got to grapple with, and we have to deal with as a society. I will say, this is probably the part of my answer you won't like as much, that the way in which we deal with those is through a judicial process, and the way in which our judicial process works is one that it tries to ensure that people are treated fairly, and that means that the accused are treated fairly. Now that comes sometimes at the expense of the victims, and that's a legitimate concern to raise, and it's a legitimate problem. But I also don't think we want to live in a world in which, let me digress for a second, and something implicit in what you said when you said Caucasian judges or Caucasian male judges. Yes, right. More diversity in the core of people who are the decision makers in these cases would be a really, really valuable improvement that I think would ameliorate, wouldn't eliminate, but would ameliorate some of the problem you're perceiving. Definitely, definitely. but I don't think we want to live in a world in which you extinguish all process. And so I think striking that balance is imperative. You can argue that the balance isn't being struck appropriately now, although, as I said, I think that does have more to do with the decision makers and their perspectives rather than the decision-making process per se. But anyway, so that's my sense of it.
Great. Next question. If we can go to the third row by the shelves.
Barack Obama, in his final few months, said that his biggest regret was his inability, the inability of the United States Congress to pass common sense gun laws. And I just wonder if you feel that you had any power to further that agenda, and if you did, do you regret not doing so?
So, virtually every hot-button, divisive issue of American politics came up during my tenure as Solicitor General, except guns. I went 5 years, I did not have a single case about guns or the Second Amendment. It never came up. Had it come up, I'm quite confident that in line with the President's view, we would have taken a position that, yes, we acknowledge that the Second Amendment of the Constitution guarantees an individual right to bear arms, but there is considerable latitude for regulation to protect public safety, consistent with that guarantee. I'm sure that we would have taken that position and we would have taken it aggressively. But the opportunity never arose to take it, and so I didn't really have the chance to do that. And I think the President's regret is principally focused on the legislative process, the frustration that he felt that even in the wake of horrible tragedies that he as President had to help guide the country through, in Newtown, Connecticut, the slaughter of all those school children, the racially motivated slaughter of the folks in South Carolina in the church. Those were incredibly painful, searing incidents for the country. And one would have thought that if anything could motivate the legislature to actually act in a common sense way, it would have been those, and yet it didn't happen. And so I think that's principally what the President was reacting to.
Great. Next question. Can we go to the third row on this side?
Hi.
You have a question. What a shock.
Yeah. I actually have a question about abortion, and I know like a lot of conservatives in America and particularly in the legislature talk about overturning Roe versus Wade and wanting to get judges on that are going to overturn Roe versus Wade. And I wanted to know whether that's like a legitimate concern to have. And also with your comments in regard to race and to like recently with LGBTQ rights, do you think that applies to women's rights as well? Because there is obviously a lot of variation in the states and how easy it is to access abortion. And do you think that's an issue under equality for all under the law? And how do you think that should be addressed in the judiciary?
Yeah, there's a lot in those questions. Let me try to sort of go through it as best I can. So, I think that the question of whether Roe v. Wade, everybody knows what Roe v. Wade is the case that enshrines a constitutional right to reproductive freedom of choice. I think it is seriously at risk, not right at the moment with the current configuration of the Supreme Court. Assuming that Judge Gorsuch becomes Justice Gorsuch, I would anticipate that he would be a person who doesn't agree with Roe against Wade, and neither does the Chief Justice, neither does Justice Alito, neither does Justice Thomas, so that's 4. But just recently, in my final term in 2016, the Supreme Court decided a case about abortion rights coming out of the state of Texas. And it was a law that imposed very onerous health code and medical safety code requirements on abortion providers that were out of all proportion to the medical risk that abortions posed. And they were challenged as infringements of the right to reproductive freedom. And the Supreme Court did strike that Texas law down in a case that I argued. basically on the ground that the laws weren't on the level, that they were ostensibly done to protect women's health, but everybody understood that they didn't have any health benefit. In fact, they probably were detrimental to women's health, and their goal was simply to make it more difficult to get an abortion. And the court struck it down with Justice Kennedy providing the deciding vote. And so you look at that, and I don't think that there's really any chance that the court, as configured now, even with the addition of Justice Gorsuch, will strike down Roe against Wade, or even will meaningfully cut back, allow the cutting back on the right to reproductive freedom. If there's a second appointment to the court, in which Justice Ginsburg or Justice Breyer or Justice Sotomayor or Justice Kagan is replaced, then the calculation is totally different. And I wouldn't anticipate, even in that circumstance, that the very first thing that would happen is that they would overturn Roe against Wade, but I would envision a series of cases in which the right which states regulate very aggressively, and that the state regulations are upheld, not on the theory that Roe against Wade should be overruled, but on the theory that it should be interpreted more and more and more narrowly to the point of invisibility, and then at that point they'll, probably get rid of it. And so the last part of your question, though, is quite important, I think, in that, and it it's a similar kind of thing about marriage equality. Basically, under our constitutional system, a lot of these decisions get made under the rubric of the 14th Amendment's fundamental guarantees, and there are two. And one of them is the right to the equal protection of the laws, and the other one is the right to due process of law. And the right to equal protection, everybody understands. It means, equality of treatment. Now, exactly what that means and exactly what kinds of distinctions are consistent with that constitutional guarantee and what kinds of distinctions aren't is a subject of great contention. Everybody understands what it means. The question of due process of law has been much, much more contentious. And Roe against Wade was grounded in that idea of due process of law, that you had a substantive due process right, that there was a zone that the Constitution protected from government interference under that rubric of due process. Some have thought, including Justice Ginsburg herself, she said this in a speech at one point, some have thought that the right to reproductive freedom would have had a more secure constitutional foundation had it been based on the right to equal protection of the laws, on the theory that women can't participate equally in society without recognizing reproductive freedom. And so, that proposition, if there is a change in the composition of the court I described, we may see that. And similarly in Obergefell, which was the case that recognized marriage equality, the position that there were two arguments made, the same two, constitutional due process and constitutional equal protection. On behalf of the government, we argued only the equal protection argument and not the due process argument, because we thought that was a more secure constitutional foundation. That basically what you were talking about was equality before the law, that couples ought to be treated equally, more than that you had a substantive due process right to marry. The decision that Justice Kennedy wrote has a little bit of equal protection in it, but it is mostly substantive due process. And I think it will endure. I'm not really terribly worried about it, but if I have a residual worry, it's that I wish that decision had been more rooted in the equal protection norm, because I think that's much harder to argue with.
Great. Next question. Can we go all the way to the back, just on the left by the books? Yeah, around there. Yes.
You talked a little about how if you'd had your Senate confirmation in mind, you would never have taken on the death row cases. Yeah. When it did come to your Senate confirmation, what were the issues which came up, and what caused 16 Senate members to vote against your confirmation?
Yeah. So having 16 senators vote against you is actually a very small number in the modern day and age. I think I was the last person in the administration to get over 60 votes from the Senate. But my nomination came along, who knows what the answer to that is? Some of the senators basically said, this sounds a little bit, this has a little bit of an edge to it, but so be it. Some of the senators said, well, you seem like you're a very able lawyer and you're qualified for the job in that sense, but you need to be a person of integrity to have this job, and anybody willing to stand up in court and defend the things that Barack Obama is doing lacks integrity, and therefore I'm not going to vote for you. That's a little bit of a parody of what they said, but not really that much, actually. But it came up in a particular framework, which I understand. That in the months that preceded my nomination, the President and the Attorney General made the decision that they were no longer going to defend the constitutionality of the Defense of Marriage Act, which was the law I described earlier, saying it was a federal law that said that the federal government would not recognize same-sex marriages for purposes of any federal benefit programs. And the President and the Attorney General made the decision that that was an egregiously unconstitutional law that they weren't prepared to defend. That was a very unusual step for any president or attorney general to take, because there's a very strongly ingrained norm in our system that the Department of Justice defends the constitutionality of statutes that Congress passes. There are some exceptions to it, but it's very strongly ingrained norms. And the Republican senators were quite angry about the decision of the president not to defend the law. And my confirmation hearing, just as things happened, happened to be the first occasion in which they could publicly express that anger in a systematic form. And I had not participated in the decision not to defend the Defense of Marriage Act, DOMA, for an ethics reason. My prior law firm that I'd worked at before I went into the government had brought one of the challenges to the law, and we had all signed an ethics pledge saying we would not work on anything for 2 years involving our former employer, and the decision was made within that 2-year window, and I didn't work on it as a result. So the senators couldn't blame me during the confirmation hearing for having actually made the decision not to defend it, but they went after me for being willing to carry out the decision not to defend it. And they did. And virtually every single question from a Republican senator on the Judiciary Committee, you go through a committee vote first and then you go to the full Senate for a vote. And virtually every single senator on the committee, Republican senator on the committee, spent all of his, I guess they're all of his time attacking that decision and pestering me with questions about that decision not to defend. Now, despite that, all but one of those senators, happens to be the senator who's now the Attorney General of the United States, Jeff Sessions, but all but one of those senators on the committee actually voted for me. But when it got to the floor, there were however many it was, 15, 16, whatever, who went with Jeff Sessions and voted against me.
Too few. Next question. Can we go to a member in the second row with a tie on?
Hi there, thank you very much for your talk. I was actually thinking about what happened to Judge Garland at the end of the previous session and all that has gone on since then. And I was wondering, what do you think about the future of bipartisanship within the United States? And do you see that actually having any impact on the way in which Supreme Court justices are picked in the future?
Yeah, so it's a terrible problem, I think. You all know in case you don't, the facts of the situation. The vacancy on the U.S. Supreme Court that arose in February of 2016 during Barack Obama's term. He nominated Merrick Garland, who is extraordinarily well qualified by universal acclaim, and who was quite a centrist, actually. He was nominated in March of 2016, and the Senate never held a hearing, much less a vote, on whether to confirm him. And the norms around the Supreme Court and judicial nomination and confirmation process have been eroding over time. And in truth, both parties have contributed to that erosion of the norms over time. But this was a gigantic step in the wrong direction, the Merrick Garland thing, because essentially what it said, at least as far as I'm concerned, what it said was, Yes, you're a person of integrity. Yes, you're qualified by your intelligence and your experience and all that to be a Supreme Court justice. But you know, a different president, if the Republicans win the election, would pick a different person who will vote differently than you would vote. And therefore, we're not going to give you a hearing in order to preserve the possibility that we will end up with somebody who will vote differently than you would vote. And lo and behold, that's what's happened. And I just, you know, I think it poses a real dilemma for Democratic senators and for those of us who actually care about the integrity of the court and care about the integrity of the judicial process and want to preserve it as not a partisan political operation. What do you do now in that they've gotten away with this? You know, they've engaged in this gross violation of norms and they've gotten away with it. It's a very difficult decision because on the one hand, your instinct is to say, well, we can't let them get away with that. We got to, you know, do everything we can to stop it. On the other hand, doing everything you can to stop it, it just further erodes the norms that you care about. So it's I mean, you know, I don't know what the right answer is, but it is a really tough problem. And I think we will look back in America on that decision not to give Judge Garland a hearing and not to confirm him to the Supreme Court as a deeply damaging moment. And whether, you know, time will tell whether we come back from it or whether it precipitates a horrible slide downward further. But I think people are going to look back on that as a deeply damaging moment.
Right. Next question. Can we go to member at the back in the red jumper?
Thank you very much for your talk. I just wanted to ask a more general question, sort of related to politics versus law. What would you have to say to legal theorists who say that modern Supreme Courts stray too far from the letter of the Constitution, and in particular with their use of the 14th Amendment?
Well, this is a hard question, sure. You know, in any time, we have, our system involves recognizing that the Supreme Court has the power of judicial review, which means they have the authority to invoke the Constitution to overturn the decision of the democratically accountable branches of government. You know, that's an extraordinary thing. And it has to be exercised with caution. And one way in which the argument is made that you need to exercise it with caution is to say, well, you just have to hew directly to the letter of the Constitution, and more particularly to the original understanding of those who enacted the words in the Constitution that are at issue. And that argument has a lot of force. I understand it. The problem, though, is when you think about the 14th Amendment, the words that are often at issue are the following: no state shall deny any person the equal protection of the laws. Well, you know, that is not a self-executing phrase. You have to figure out what that means in particular circumstances. And one way to do it is to say, well, what it means is that it should invalidate only those government actions that those who enacted the law contemplated at the time it would invalidate, and those are only laws that treat African Americans as second-class citizens. Problems with that are, we'll start with problem one, is it was quite clear from the historical record. A few people have tried to make a different argument, but it's, I think, generally understood to be unpersuasive and not supported by the historical materials. You know, in the United States, in the immediate aftermath of the passage of that language in the 14th Amendment, there was rampant official segregation by race by the state governments, and sometimes even by the United States Congress. And so really, you're going to interpret the 14th Amendment? So that would mean that the most iconic decision in American judicial history, Brown against Board of Education, was wrong, right? And that, I mean, that's like, you know, that's what you're kind of signing on for if you think about things that way. And when you think about it in those terms, it becomes very hard to get your head around that being an appropriate approach. And I think the reason for that ultimately is that the people who enacted that fundamental law were enacting it, they could have made a choice. They could have written into the Constitution a provision that said, no state shall discriminate in its official actions on the basis of race. Could have said that. But they made a deliberate choice to say something at a higher level of generality, I think understanding that this was a fundamental principle of human rights that was going to apply in a multiplicity of contexts. And they had the confidence in future generations of jurists to apply that law in a manner that was responsible and respectful of the constraints on judicial authority, but that went beyond the initial impetus for its enactment. And the Constitution has lots of provisions like that. You know, the guarantee of the freedom of speech. Well, that's great. You have to know what the freedom of speech means. You know, what's within the ambit of the freedom of speech that the government cannot restrict? That's not a question that answers itself. And so I think if you want to originalism has a lot of power to it as an argument. I don't dismiss it. But I just think when you're dealing with these provisions that were written at a high level of generality, they were likely written at a high level of generality in anticipation that they were going to apply in all kinds of unforeseen circumstances, and that their authors had confidence that jurists in the future would do that responsibly.
Great. Can we go to the member in the fifth row, I think it is?
Thanks. Would you be able to speak a bit about working with the justices of the Supreme Court? Like, which ones did you particularly enjoy arguing against, and which ones gave you the most trouble?
They all gave me trouble, and it's quite interesting. In 1984, 1985, I served as a law clerk to Justice Brennan, and so I was able to observe the oral arguments of the court back then. And back then, lawyers could go on and on and on without being interrupted with a question. They would get 5 and 10 minute stretches where they could talk. The arguments tend to be 30 minutes per side, and the big cases, they may make it 45 or 60 minutes per side. Now, and it was basically the arrival of Justice Scalia in the late 1980s. He was an extremely, extremely aggressive questioner from the bench. And he got the rest of his colleagues all juiced up to do the same thing, basically, to the point where now it's in the vast majority of arguments, and certainly all the arguments that when I was Solicitor General I was doing, because they tended to be the most important cases, we would plan, as part of our argument preparation, that you would do an opening statement, and you would assume that you would have no longer than 40 seconds to make your opening statement, because we just sort of, by historical experience, that's about as much time as the justices would leave for an advocate to make an opening statement. So 40 seconds, a normal human pace of speech, is 100 words. And so basically what we would do was try to distill what we had to say, the most important thing we had to say, into 100 words or less, because we realized we weren't going to get more than 100 words. So that was sort of part of it. Part of it is that 8 of the 9, when there were 9, were extremely active questioners. And particularly in a 30-minute argument, there's just not that much time. And it's a little bit like a game show, actually, in that they each have a microphone in front of them, and they have to hit a button to activate the microphone to get their question. And so they all sit like this, and they wait for the moment when there's a little break in the action. They can hit their microphone and ask their question. And their questions, in any case, there's a whole wide range of things that one might want to ask about. What does President X say? What's this fact in the record, et cetera. And each of them may have a different point of emphasis, a different thing that they're interested in. So they're always pulling you one way or the other way. And then you add on to that the fact that there were some of the justices were particularly strategic in the way that they asked their questions, and that if they were against you and they thought you were getting up ahead of steam, they would try to knock you off balance. And over time, I got sort of a better feel for how to deal with that. As Solicitor General, the Supreme Court would have 7 argument sessions a year, and the Solicitor General, by tradition, argues a case in each of the 7 sessions. So I got to do it a lot, and Eventually, it took a little while, but eventually I figured some things out. I mean, Justice Scalia was the most aggressive questioner. And early on, he used to knock me off balance because he was incredibly aggressive and he was incredibly smart. But eventually I realized that he wasn't, although it seemed very personal to me when he was coming at me, that he actually wasn't taking it personally. This wasn't personal to him. He was just making a point about the law. And that, therefore, I didn't need to worry that he would take it personally if I was just as aggressive back. And so it took me a little while to get the hang of that, which was, he punched me in the nose, I punch him right back. He punched me in the nose again, I'd punch him back again, and then he would stop. And I could kind of get on to making the points I wanted to make. Justice Alito was probably the justice who was most consistently against the positions I was advocating on behalf of the United States. But he's a very, he was extremely well prepared for the arguments. He was an extremely adept questioner and really smart. And he's got very strong points of view, but he's a very principled adherent to his strong points of view. The thing about Justice Alito was that he was very polite. So he could ask a really difficult, often very obnoxiously formulated question designed to put me in a trap. But I knew that, and I got a hang of this eventually too, I knew that because he's a polite man, he would give me time to answer his question. And so I realized that actually, as difficult as his questions were, they were actually opportunities for me because I could give a long, uninterrupted answer. As long as I continued to look at him the way I'm looking at you now, just like don't let my gaze wander from him, so that others would think it would be rude to interrupt because I was having this conversation, that I could give a long answer. And I could actually kind of pivot and use it as an opportunity to make a bunch of points that I wanted to make. And so it took, you learn from experience, and that's the person who I had the most trouble with was the Chief Justice. He had been an oral advocate in front of the Supreme Court and an extremely able one for many years before he became a justice, and so he knew exactly what he was doing up there. And if he was not predisposed towards my position, he could make. And he was the Chief Justice, so you have to respect him. You have to respect all of them, but in particular, Chief Justice. And so he could be quite challenging. But eventually I think I even got the hang of it with him too. But it is an interesting thing. They tell you that you should understand oral argument before any tribunal, and particularly before the Supreme Court, as a conversation. You're having a conversation with the justices in order to help them reach the correct result. And it's true that it's conversational in format, but it's not a conversation. It's an effort actually among the justices to persuade each other, and the lawyer is just instrumental to that. They're trying to ask you a question designed to elicit an answer that they think either will be persuasive to the justice whose vote they think will be critical in deciding the case, or that they think will be repellent to that justice, depending on what their goal is. And so it's just a very, very active process, and all of them, Justice Thomas seldom participated in the arguments, but all the rest of them participated all the time, and so any given day, any one of them could be making your life a living hell. So.
Great. Sure, can we just go over here, please?
Thanks. The separation of powers is a key principle in US constitutional law, at least in theory, but in practice it seems like the use of executive orders by the president sort of blurs the lines. And I think Obama was one of the more prolific users of executive orders, and it seems like Trump in recent times has already got a bit of a partiality to do so. Do you see any concern or any threat to the separation of powers with the use of, or the increasing use of executive orders by the president? And if so, do you think there's a role for the Solicitor-General to play in counteracting that at all?
So, I don't mean to, I'm not necessarily pushing back on the premise of your question. Presidents have used executive orders for a very long time and with some frequency. It may be true that the recent presidents have used them more frequently. I'm just not sure that that's empirically true. But whether it's more frequent or not, the use of them does raise the issue that you've identified. But I think one has to look carefully at what the executive orders are and what they invoke as the source of their authority. And the key thing in our system, I think, is that for separation of powers purposes, and you're quite right, that's a fundamental norm that makes our system work. The key thing, I think, to look at is the president claiming to implement authority that Congress has granted in a statute, in which case what you have is a question of interpreting the statute, and ultimately the judiciary will, in the vast majority of instances, decide that question. And so the separation of powers works out in that circumstance. Or are you in a situation where the president is claiming inherent authority by virtue of being the chief executive to take actions whether or not Congress has authorized them, and sometimes even in defiance of congressional restrictions on presidential authority? In those circumstances, it seems to me, it is those circumstances that raise the separation of powers issues more acutely. Now, there are some circumstances in which the president does have authority directly conferred by the Constitution to do certain things, even if Congress hasn't granted that authority. And there may be some circumstances, there are some circumstances, they're pretty rare, but there are some in which the president has authority on the Constitution even to override judgments that Congress has made. And I argued one of those cases actually on behalf of the administration. It was quite an interesting case, separation of powers case. Congress had enacted a law in I don't know when it was, 2000, maybe the 1990s, in which it said that any American citizen born in Jerusalem had a right to have Israel listed on his or her passport as country of birth. That was a problem because going back to 1948, when the United States first recognized Israel as a nation, it carved out the status of Jerusalem. It said, we're not recognizing any nation's sovereignty over Jerusalem. Same thing the United Nations did in the 1948. So that's got to be worked out between the parties. And so every administration had, from 1948 on, had adhered to that position. George W. Bush administration did it. When the Obama administration came in, they did it too. But Congress had enacted this law that essentially said, we, the Congress, are going to deem Jerusalem to be part of Israel, such that if somebody wants to have Israel listed as their country of birth on their passport when they're born in Jerusalem, they can. And so we made the argument to the Supreme Court that, and somebody wanted to have their nation of birth listed as Israel on their passport, and the executive branch wouldn't do it, and they brought a lawsuit, and it worked its way to the Supreme Court. And we made the argument that this was one of the rare situations in which actually the power to decide to recognize foreign nations and to recognize the borders of foreign nations is one that rests with the executive, and that Congress can't infringe it, and therefore that this law is unconstitutional. And we actually won that case 5-4 in front of the Supreme Court. So there are some examples in which there is unilateral presidential authority, but they're very rare. It's a long way of making the point, I guess. They're very rare. Most of the time, the issue is going to be, is there legislation authorizing this action by the president? And much of the time, that can be tested in court. And then, in addition to that, and I do think there's a risk in this, and the executive order that we saw come out with President Trump on immigration, I think, is an example of it, that it's very easy to just sit at your computer and pound out an executive order. But it ought to be, if you're going to do it right, it ought to be preceded by very thorough policy consideration and very thorough legal consideration. And before issuing an order of the kind that came out in January, one would have expected that there would be a thorough analysis by the Department of Homeland Security as to whether existing regulations as to refugees and as to immigrants from the 7 identified countries were inadequate to the task. There would have been a thorough analysis of the implications for the military. For example, we have all these interpreters who we've promised visas to who now can't get visas. There would have been detailed analysis of the interests of the intelligence community, where we have promised a bunch of sources in foreign countries that if they ever got in trouble, we'd give them a visa, and they could, and now we can't. And then you would have thorough consideration of the diplomatic consequences through consultation with the State Department. And none of that went on in any meaningful form. And then also you would want really rigorous legal analysis within the executive branch as to whether there is authority to do what the president's doing. And by rigorous legal analysis, I mean, very detailed study. The Department of Justice has an office called the Office of Legal Counsel, and that office's job is to weigh in on the lawfulness and constitutionality of executive branch actions. And when they are asked to give opinions, they give very thorough, detailed opinions, and very often say the president can't do what the president wants, or the president can only do it this far and not further. And you'd want to see that kind of thorough consideration too. And those sorts of steps, they're internal restraints as opposed to external checks for separation of powers, but there are internal restraints that come out of a notion that the executive ought to exercise some self-restraint to respect the separation of powers. And I do think whatever one wants to say about whether President Obama went too far in the use of executive orders, I think you will find that his executive orders were invariably preceded by both that kind of substantive policy analysis in great depth over long periods of time and in-depth substantive legal analysis before acting. And I hope the new administration will follow that approach. They didn't on the first one, but I hope they will.
I think, unfortunately, this is all that we have time for this evening. May I ask you all to remain in your seats, and I thank Mr. Verrilli for his time, for his effort to fly transatlantically to see us, and if you can all join me in thanking once again Mr. Verrilli for addressing New York City this evening.